If you're married, can you file bankruptcy without your spouse or significant other? If you're not married, you have a significant other. Maybe. The answer is yes, you can file alone. But Joe Biden and his Republican friends, he used to be called the senator from MasterCard, put in a means test qualification into both Chapter 7 and 13 filings. So you're going to need an experienced Geraci Law attorney if you're not the sole income producer in your household. If you're living with someone who has income that you share along with expenses, that's called household income. You probably know how much income besides yours supports the household. We do have people that say, I'm married to my spouse. She's always had her own stuff. It's a second marriage. I don't know how much money she makes, and I don't know what she spends it on. Then that's not household income. But if you share a bank account and you're sharing expenses, you have household income. Now, these other income contributors don't have to file a bankruptcy case. They may want to, but they don't have to. Only married people, in fact, can file joint cases. If you're not legally married, you must file a single case. Well, you say, well, I'm living with someone and we do share bills, we've got joint accounts, we want to file a joint bankruptcy. They have to be separate cases if you're not legally married. Even if you are legally married, your spouse may file separately and even file Chapter 7 or 13 when you're doing another chapter. So there's a lot of variation. A spouse's case filed separately is a related case. That will be assigned to the same judge and usually heard at the same time if it's the same chapter. So they're related or companion cases. Often, other household earners or spouses will have no reason to file, but their income, and in community property states like Wisconsin, their assets that are community property, and there's such a thing as community debt of the non-filing spouse, have to be considered so that we can protect them and you. Another wrinkle is when a married couple holds property jointly or by tenancy by the entireties. Entireties property is protected from sale by creditors during the life of the couple, during the life of the entireties, the marriage. But if both file bankruptcy, then it's not. So we have to watch that also. Joint tenancy or common tenancy property is another topic that may have non-exempt equity if one tenant did not sign the mortgage. So you have joint property maybe with your mom or your dad, but you didn't sign the mortgage. Somebody didn't sign the mortgage. Somebody signed the mortgage, but they're not on the deed. A lot of problems there that we can watch out for and keep you safe from. So, if your spouse or significant other, or even your joint tenant, doesn't want to do anything, they don't have to. No law that says they do. But if your filing involves them, such as when there's joint or community property, income, expenses, or debt, it's something that we want to discuss. That's why it's so dangerous to pick a lawyer carelessly, or worse yet, go to an attorney who does bankruptcy cases suspiciously cheap. You may find that the cheapo depot will not get you where you want to go.